And Mr. Myers, did you date it?
Oh, I'm sorry.
Can I put? You mind if I put the date on?
Go ahead.
Would you rather do it?
It doesn't matter. No.
Okay.
It's fine.
So today is the 28th.
Yeah, I just realized there was a hearing today. It's already in progress. I don't know how much we've missed, but
You did, and yet for the other case.
I think it was right when I was leaving or something.
here we are.
Okay. So what do you want to tell me?
So again, the very same thing that I just talked about prior about the advisory council just got brought up again because I had asked if I could, talk to Rachel for a second, and Rachel seems to think that she can only talk to me, Miss Stiles, excuse me, if advisory council is present. No, that's the point. The advisory council does not represent me. They're advisory council.
Okay. I'll make a rule on that. Ms. Stiles, what's your position on that?
So, Your Honor, my concern is that he is constantly claiming that I am misleading things, misrepresenting, doing all of these things. For his protection, to make sure that we have a clear communications, it makes sense to me for advisory council to be present, as well as the fact that if advisory council needs to take over at any point, if he decides he doesn't want to represent himself, it's better if advisory council is familiar with everything that's happened. So what I would do is we could facilitate where we have a Teams meeting where all three of us would be present on it, but he would be speaking to me directly, but advisory council would be there listening and then could give him advice as he needs it.
No.
Well, what's wrong with that?
Because the whole point is I'm representing myself. If I want them to know something, I'll tell them. I don't need these people looking over my shoulder. I don't want their advice. You're forcing them. First of all, I respect your inherent authority to force me to have advisory council, but I'm making it very clear I don't want these people and I don't want them involved in my case in any way, shape, or form. In fact, I'm going to ignore them. Okay, I'm not going to say a single word to them. I don't even want them sitting next to me. And she's trying to make it seem like they got to be in every conversation. That defeats the whole purpose. No, I'm representing myself. You come to me directly. I'm not going to have to work around their schedule. That's the whole point. These hearings, I got all day. These people, we can only talk when they're available. And no.
Mr. Myers, I understand. I'm going to order, Ms. Stiles, that you communicate with Mr. Myers directly. I agree with him. If he's self-represented, he certainly has the right and authority to discuss that directly with you. So,
Your Honor, I just want to make clear that if he engages in abusive conduct, I will end the meetings with him.
Okay, you got to be professional.
Yes.
So
we got to get to that point, though, right? We got to actually get to a meeting before I can be professional.
Wait, I just told you that you could talk to her directly.
I know, I appreciate it. I was just rebutting what, I just wanted to clarify, or,
okay.
clear up her concern.
So the next thing I want to discuss, now that Mr. Myers represents himself in both matters,
thank you.
It seems to me that the cases could be consolidated. And Ms. Stiles, are you going to file a motion to that effect?
Yes, Your Honor, I can.
Okay.
She said three times
we could do it today if you.
Yeah.
Do you want to?
Do you actually want to do that now?
Yeah, I mean, the court's been asking her. I've been trying to do it. That's why I tried to do it last week.
Okay.
Because the reason that when they become consolidated, is it all one case number?
No, it's still two case numbers.
Okay. Because I need to file this Rule 10.1 on both on the whole encompassing thing. So somehow we need to get them together. So I don't need to file two separate motions on everything.
Right. So they'll be consolidated for purposes of trial.
Right. And motions.
And motion. Yeah. Okay. Well, trial meaning that trial proceedings.
Thank you.
So, but they retain their original CR numbers because they're two different indictments.
So I'm gonna have to just write both on each motion.
Correct.
But not two separate motions like I'm doing now.
Correct.
That's what I'm trying to avoid.
And that's what they do, right? It just has both CR numbers. So put both CR numbers on your motions, okay?
Thank you.
So based on the stipulation of the parties, the court orders that two cases are consolidated for purposes of trial and litigation, but they'll retain their same CR numbers as each one reflects its own indictment. Next, we have a trial date in the new case 1454 that Judge McDonald put on the calendar. I believe it's July 21st, and I'm inclined to consolidate those both for trial on that date. And I checked that both that's within speedy trial as the first case.
Can I bring up a concern with that?
Sure.
They're trying to call my wife. She won't be available. I need a case before July 4th. She's going international at that time.
I'm going to set it when I'm going to set it. I can set it later. I can't set it faster.
I'm just sitting in jail, though.
I had 300 cases.
Oh, I feel you. But okay, well, so let's pause there for a second, and I don't mean this in a threat.
And I'll tell you, most cases are older than yours, even with people in custody. So there's nothing that's special about your case that would jump.
I feel you. I feel you. Are we still going to have the hearing next Monday? Because
Well, I don't know that we had another hearing set.
Yeah, May 5th.
What was that for?
That was for you because you were going to do research.
Oh, okay.
And all this, and we were just going to set the trial. The concern I'm having, the reason I want to kind of pump the brakes a little bit today is because I wanted to have this Faretta hearing, consolidate the cases, and adjourn, because and I don't mean this in a threat. Please don't take this as I'm trying to push, I'm just saying, as a ripple effect of what I'm about to do. The case is going to get reassigned to a new judge, and then we can set that on their schedule. So then you might set a trial date, and then next week it's in front of a new judge, and that trial date don't work for that judge. Because I'm going to put the rule 10.1 in when I get back to the jail, but I needed to be on both cases to do that and to have them consolidated. And then once you do that, you're going to have to reassign it. You're going to have to, the process.
Right.
But then, I feel it's going to get reassigned just because you're clearly breaking some laws.
We don't need the May 5th hearing right now, correct?
Correct.
Would you agree, Mr. Myers?
Yeah, that's what I was trying to figure out, is because wouldn't it be redundant because we withdrew the bail hearing?
Yes.
Because the bail hearing was supposed to be within 7 days of him filing, so you already went way past that. And in Dominguez and Metcalf, I read your thing, so I'm already scared that you don't follow the rules of procedure as they're written, and so that's why I think it's best that if I just put this rule 10.1 and we get this moved to a different judge for everybody involved. And then, not just because of the hearing, but for multiple reasons, including you just denied 122 again. But, so once it gets assigned to another judge might not have those days available, and then we got to go through the whole Rule 8, extenuating circumstances. I'm not waiving Rule 8. They're going to have to get permission from the Supreme Court to adjourn, to stop using Rule 8, all that. So I just feel like...
Well, how about if we set a hearing on May 12th to set the trial date? That's 2 weeks from now.
In the event that it doesn't get reassigned?
Yes. Well, it would still be on the calendar. If a new judge gets assigned, that judge could keep that 12th date or could
for the 12th date for the right, but not lock the trial in today. Use that as the next date to possibly set trial.
Exactly.
That's what I meant.
Okay.
Thank you.
So I'm going to set May 12th as a status conference to set trial date in both CR matters, which will be one trial. I'm telling you that I'm inclined, if the presiding judge doesn't remove me from the case, to hold the
21st.
Have the 21st as a date. And if you say that you have a material witness who can't be there, it's going to be later,
they do.
not earlier.
Right, they do. So the thing, okay, so
Hold
then...
on. No, I
oh, my
thought
bad.
it was your witness.
No, they said they're calling my wife to testify against me.
So I want to clarify, it's not his wife. They're not actually legally married. And
Time out. No. You got to stop. What we call...
So
hold on.
there-
Hold on. Mr. Myers,
I'm standing on business with this. They need to stop telling me what I call my wife.
Mr. Myers,
If we...
hold on.
No, they don't. They keep putting this in motions and putting it in quotes and all this.
Hold on. Just let me talk. So,
It's
hold
disrespectful.
on. No, what they're saying is there's a privilege between spouses.
We know what that is.
Okay. But you can only
We're
claim
not
that
exercising it.
hold on.
Nobody's exercising that. Nobody...
That's what she's mentioning.
No, but they're putting it in motions too. Stop disparaging our relationship.
No one's disparaging it.
They put it in quotes like, "Oh, he claims it's his wife." What do you think? I'm secretly claiming my wife and she doesn't know it?
Hold on. It's only as to whether the privilege applies. That's what
Nobody brought that up.
Okay, that's why she's
They brought
doing
it up in motions.
All right, Mr. Myers.
His wife. They brought it up in a disclosure thing.
All right. I understand,
his
Mr. Myers.
wife, but they're not married. We can be in a relation. You don't have to be legally married so that that's to protect assets.
It's only to talk
Legal
about the
reasons.
privilege.
No, it's not. It's to be rude and disparaging.
No, they're not being rude. They're not.
Okay, well, I'm going to call her the fake victim then.
No, we're not going to do that. That's disrespectful too.
Well, she's not really a victim.
Mr. Myers.
It's like she's not really my wife, right?
Remember, I allow you to hold on. Hold on.
They're picking at this. They've been doing this over and over, though.
Mr. Myers, I allow you to represent yourself if you're respectful. Okay, that's a rule,
all right,
and I had the chance to pull that. Okay.
respect.
The only reason she mentioned that was as a privilege, and we're not talking about that today. So, Okay.
And just to clarify, that is the reason I'm bringing it up, because when in a legal proceeding, if you refer to somebody as a wife, that triggers certain legal things. And so that's why I'm clarifying that for the court.
Right.
And we will take care of that. So if she is going to be unavailable, we will file for a deposition if need be. We will take care of our things that we need prior to the trial date. So I'm not concerned.
I'm not setting the trial date today, but we're going to come back on the 12th.
Yeah,
and I'll set the trial date of the 21st of July. That's a good date for me, and it was already set, and it's within speedy trial.
Gives enough time to, well, because the last hearing was, they were talking quantum physics, and we should have been taking kindergarten math, but for some reason, all right, so he did bring up you extending the 12.9 in the 1454. I just want to make sure that got put on the record.
Did we do that last time?
I mean, we brought it up, but it kind of got swirled in with everything at the last second.
So we just got the transcript. At least I just got my copy today, so I imagine we will get, the court should be sending him his copy.
Hold on. What are you talking about? The transcript of the grand jury?
Yeah.
We've had that for 3 weeks.
The 1554 transcript?
Yeah, I've had that for 3 weeks, and I've been trying to extend the 12.9 since McDonald was hearing.
It was just slower to me. So I don't think we actually accomplished that the last hearing to extend it. I'm fine giving him another.
Because it is in the first, remember you did it in the first one?
All right, Mr. Myers, what's the date you want?
You extended it from 45 days to 60 in the first one. So if you could do the same thing to refile to remand, 12.9 remand.
I have no objection to that.
No, I realize that's getting close to. It's kind of like you're playing with both sides there. The trial is within so many, and if you do that, it's not that I'm going to take that long, because then that would interfere with the trial date and all that.
Right.
And so,
how about if I give you 45 days?
That's fine. Yeah.
All right.
From today or what?
From today.
Yeah. Okay.
Yeah.
Yep.
So I'll grant, and this is in 2025-1454, extend the deadline for remand of the grand jury.
What is the actual date on the calendar? Let's see. Because when you file that, it stops time, right? But what does it do for a trial date that's already set?
It excludes it. Well, it depends on whether we can if it's granted, then it has to go back.
Well, no, I know what I'm saying, because like 45 days, so trials is, July 20th, it's April 28th, so May, so we got 90 days, okay, so 45 days. That would still give time to file the 20 days before trial and all that. I'm just trying to count backwards. So everything, if we have the July 21st trial date, I'm going to have everything by like July 1st, basically, end of June. Any motions that need to be 20 days out. So that'll give me all of June and all of May. Okay. Thank you.
It would be June 12th.
June 12th.
But remember, Mr. Myers, if the court grants your motion,
they will.
Then that reindict you, then that's going to extend the trial date.
They committed. So I wanted to ask you this as a matter of course here. Do you get a copy of that? Because she's saying because I'm
get a copy of what?
The grand jury. Because she's saying she just got it.
I don't get that.
I've had it, so I'm trying to figure out here. So you don't get a copy of it?
No.
Because you used it in the slap motion. How did you get a copy of it for that? You denied the slap motion. You referred to it about 12 times.
Maybe I did get it.
You referred to the grand jury transcript about 12 times.
I think I asked for it.
Oh, you asked for it?
Yeah, typically it's not sent to me as a matter of course.
Okay.
But I wanted to review it because of the probable cause determination.
Can you do that again here?
What's that?
Ask for it, because the detective committed perjury.
Well, you can file a motion on that.
All right.
Yeah.
I just wasn't sure if you had that back there already.
Okay.
Because the issue I'm bringing up is like attaching it as an exhibit, and then that's my only copy.
Okay. Well, isn't there a way to photocopy things at the jail?
So when I've inquired with this at the jail, he has to put in a request for the librarian. The librarian can make copies and things.
Okay.
It's not true. She's lying. I don't want to say she's lying. I got the thing right here. We can do an evidentiary hearing on that. That they want to come testify, because she said that she talked to a captain. They laughed in my face and said, "Have me come testify under oath that what she said is not true."
Okay.
What I can do is request forms, like subpoena form. The only thing they can print me is forms. Like I could say, can I get some subpoena forms, and they're like standard forms, Arizona rule, whatever form, motion to quash a warrant form. They can print me forms that are, Arizona rules forms.
So
they can't copy anything. They can't print any case law. And when they read her thing, they literally laughed in my face and called it hearsay.
Mr. Myers, one advantage of having advisory counsel is to help you with stuff
Right, no,
like
I get
that.
it. That's why I'm not disagreeing with you about that.
Okay. So we're going to come back in 2 weeks to set a trial date unless the presiding judge grants your motion to change me.
So nothing about the Rule 15 stuff we're doing? Because you said last time that we were going to, because we got to the end of the hearing last time, and there was only 5 minutes to go, and you said we'll talk about that at the next hearing, which would have been May 5th. And the issue is
what? Just tell me. I don't want to go deep into that.
I feel you. The 15.1 stuff, they didn't meet this. Their witness and exhibit list does not meet the required standard of a Rule 15 witness list. It's just all boilerplate trash. Any and all is not. It's not. It's supposed to be the name, address, and any relevant written or recorded statements of the witnesses. It just gives their name. Then it's supposed to be lists intends to use at trial, lists obtained from or belong to. You got to make an extra list. Saying any and all photographs, that doesn't tell me what photographs you have that you might use. That doesn't tell me what police report. You need to list out, we have these police reports. Now, we might use all of these, or we might use any of these, or that you can use any and all when you actually put a tangible list of items. Just to say any and all body worn, well, how do I know which any and all you're choosing from? How do I know what any and all you're choosing from?
All right, I understand. Counsel?
Your Honor, so we send a copy of all the disclosure. So it's the disclosure he has. We can continue to modify our strategy for trial. And so as we get closer to trial, then we file a list that narrows it down to say these are specifically the things we're going to be using. But right now, he's getting everything that we could potentially use because we're sending it as disclosure.
Hold on. Is there a deadline by which?
Yes, it was May. It was the hearing with Judge. What was his name? Judge McDonald?
Correct.
Yeah, and I tried to enforce it then, and she up to that hearing, she hadn't done this. Yeah. But at late at night on that day, she forced this into the court. And if you pull up Rule 15.1 right now, she's wrong. It literally says name, address, any relevant written or recorded statement of the witness. All this says is Detective Eric Brown, case detective. That doesn't say name, address, and any irrelevant written or recorded statement of Eric Brown. And then when you get to the other list, and it's clear.
There aren't going to be any recorded statements of the detective.
I mean, then that should say that. It should say that there is or isn't witness, written, whatever. Okay, but it should say name and address, which, I mean, he's the police department. And so, but when it comes to any and all photographs, it needs to list what photographs they have. And this is where they get this scattergun approach. They give it to Parvin. And no, listen. I've beat these people in multiple cases already on this very same reason. I had them set up to get held in contempt, and they dismissed the cases in justice court because they're not physically capable or intellectually capable. I don't know what it is. I don't want to disparage them, but I'm just telling you, I've been going through this with them for 9 months. The same with Matt Walker sitting over there. It took him 5 months to give me the witness list that it was due in 30 days. And so he about got the case. Riojas ordered him to turn all this over by 5 p.m. that day, or the case was getting dismissed. And that's one reason that we're sitting here today is because I embarrassed him in court.
Your Honor, may I speak?
Hold on. The point is this needs to be more detailed. There's this is boilerplate, sir. You've been around long enough to know what boilerplate is.
I know. I understand, Mr. Myers. Hold on. Go ahead.
Your Honor, this is the same type of list that we file in every case. He has the information, so we've sent the disclosure. So he has the police reports. This is not a voluminous case where he's got hundreds of pages to dig through. It's very simple as far as the police reports in this case, the videos in this case. It's a very short witness list. And so he is on notice of the information. It's any of those videos, and we've disclosed the videos, and we continue disclosing the information, and as we come upon new evidence we want to use, we will disclose it in due course. So he has it all. So this isn't something where I understand that he's upset he doesn't have the media in his
No, Your Honor. I don't have the emails. Hold on. You do not lie under oath. You're already getting a bar complaint.
So
can he leave?
Okay.
No.
Why can't he leave?
But
he needs to leave. He needs to leave.
So
he's lying. And I'm going to outburst.
Mr. Barber, I'm going to allow you to leave.
Is there going to be an appointment? Are you appointing a reappointed advisory council?
Yes, not you though. Yeah, I'm relieving you.
Making sure that, and I just want to clarify that I am going to go make sure arrange. I can that he has everything again.
Stop saying that.
Okay.
Can you hold him in contempt? He needs to be held in contempt.
No, you need to be respectful to him.
No,
he's
he's
talking to me.
lying.
He's just talking to me.
He's lying.
If anything was missed, it'll be redisclosed to him at the jail. I'm going to arrange for absolutely everything a second.
Your Honor.
They're both saying that I have
Okay.
this stuff. I don't have it. Where
Mr.
is
Myers,
it? Am I
Mr.
hiding
Myers,
it in my sock?
Mr. Myers, you've been doing well, and you're getting a lot of
because
control.
I can't stand these people lying.
Oh, okay,
And you're
all
not
right.
doing anything about it.
Hold on.
If I lied, I'd get in
let them
trouble.
talk. Let them talk. Go ahead.
Your Honor, we sent disclosure
Thank you, Mr. Parvin, for your
to
assistance.
Mr. Parvin because he was the attorney on the record on the first case when we sent the disclosure, and then he was the attorney on the second case. And so I am happy to have us, we will send all the paper disclosure, we'll just
Yeah, do that.
The emails,
I
all
know,
that.
we'll just send that directly to Mr. Myers
Thank
at
you.
the jail. The
Thank you.
media, we will make sure his advisory council has so he can play that for him. And then when we're having a meeting, if something needs to be played for him, I can do that.
And with respect to your witness list, you do need to identify the address. With the
So-
victims, obviously the Victims' Bill of Rights, I would assume, protects
Correct.
that.
So, Your Honor, so one of the
Oh?
witnesses is his partner, and so he has her address. And
We'll
then
just list it anyway.
Okay.
And who is the custodian of records for YouTube to be determined? And how is that relevant?
We're still determining that, which
Yeah,
is why I'm.
we
So
should
how do
make-
I
notice.
pre-trial interview them without their information? That's the
They don't
thing.
have it yet. That's just a-
But they had to have that within 30 days. That's the rule. It's right in front of you.
Hold on. They have to disclose.
Continuing disclosure. They can do continuing disclosure.
Hold on, Mr. Myers. What she's saying is they haven't determined that yet. They have to disclose to you 30 days after they have the information, not 30
Oh,
days.
30 days from arraignment. Read the rule right there.
No,
It's plain reading.
They don't have it yet. It's 30 days from when they get it.
No, it's not. It's 30 days from arraignment. I don't want to argue with you, but if the rule's right in front of you,
Okay.
That's when they already have it.
It's
So typically,
in their possession. Anything within their possession within
correct.
30 days.
They don't have it.
Okay, so you're telling me they don't have in their possession all the photographs, all the witness statements, all the police reports, all the.
They've said they've disclosed. Mr. Parvin's going to get you that again, and they're going to redisclose to you again.
So I'm going to get the actual, because it says any and all emails received by the victim. Well, then I read the grand jury, and she received 58 emails in one, and she's saying this isn't voluminous. There's not a lot of things. Well, there should be hundreds of pages of emails. So how is that not voluminous?
Are there emails in the case?
Yes.
And they've been
So-
disclosed?
Yes.
Okay.
So we will.
They're going to redisclose it to you.
Okay.
You're arguing about something no one's disputing.
Well, I don't
The
have
stuff
it.
that-
I've been sitting in jail for 30 days,
Okay.
not even able to prepare because I don't. Right,
Right.
and that was the thing with Parvin. It was like I'm not disagreeing with Ms. Stiles saying. I'm not accusing her of not giving it to Parvin. I'm saying Lane Myers doesn't have this stuff.
Okay, all right.
So as far as so we have Detective Brown, who's with the Tucson Police Department. So if he wants me to specifically say the address of the Tucson Police
I
Department,
think that
can
would be
do
the best course.
And then as far as the other, we have the victim and then her spouse, and their address is protected, so he
Correct.
doesn't get those.
Okay.
No, she
Yeah.
needs to
So-
give me an address.
No.
He's
No,
a
they're
witness.
No.
He's a witness.
Mr. Myers, I'm not going to go down this.
I'm not looking for Matt Walker's address. What I'm saying is I need to be able to put out a way, because I need to do pretrial interviews with these people. So how do I contact them without their address?
You asked Ms. Stiles.
No, you do not go through the state.
No, you do.
You don't. I went through this with Matt Walker. He
I'm not-
literally told me
You can file a motion on that. I'm not going to hear that
I
today.
literally learned this from Matt Walker.
No, Mr. Myers.
state doesn't
no,
participate.
No. You can file a motion if you want to do it a different way.
I'll do what a different way?
The state provides the witnesses, and they get
No,
to
they
sit down-
don't.
Yes, that's the way it's done.
No,
If
it
you don't-
isn't.
Hold on. If you don't
Talking
like
about a
that, hold-
deposition or a
hold-
pretrial interview?
an interview. If
A
they- if you
pretrial
don't-
interview is
no,
on me to
no,
set up.
No. If you don't like the way that it's done, you can file a motion.
I read the
I'm not going
rules.
to. I'm not going to.
So Matt Walker lied to me then in court.
I don't have no idea what he said.
He told
in court.
me.
Mr. Myers, listen to me.
Why-
I'm just telling you, if you don't like the way that it's set up, file a motion.
I don't want to, you know. what I
That's
mean.
Mr. Myers.
But
Just,
what
no. Listen.
Well, somebody's wrong.
Just file a motion. I'm
A
just telling
motion
you.
for what?
To ask to interview people without the state
That's a
president.
deposition.
No, I'm just telling you the way it's done. If you don't like the way it's done, file a motion and we'll argue
The way
it.
it's done is they give you a witness list, and then it's on me to set up a pretrial interview. If those people refuse to do a pretrial interview, then I file a motion for a deposition.
You
I
can't
went through this in 9
no,
months of cases.
You
with
can't.
people.
You can't contact victims directly.
Nobody said the victim.
Okay.
I'm
If
talking
I-
about the detective and Matt Walker. They're not victims. They're witnesses, and it's incumbent
Honor,
upon me.
I'm not going to address
The
this.
state is not-
Mr. Myers, I just told you, file a motion if you don't like what
Motion
I'm
for
telling
what? There's no legally cognizable reason to file a motion to
We're
interview
done
a
with that.
witness.
We're done with that. Go ahead. Next.
Your Honor, I was just noting that in lower courts it is different about the setup for witnesses. So he may be referring to the way it's done in lower
Yeah.
courts, which is not the way it's done in Superior Court.
Right.
And so, but we will make sure that all the people are available for him to
Yeah.
interview.
And then, Mr. Myers, what we'll do is they'll arrange to have you come over to the courthouse and you'll interview him at the courthouse.
Who's
Okay?
him?
Them, the witnesses.
All right, so I got to put a motion in for that.
No, you have to put a motion if you want to do it that's different than the way that we normally do it.
So I just got a request from Ms. Stiles.
Yeah, so
Yes.
yes, so we will coordinate and we will have a
So they can
courtroom
be
made
present?
available.
Yes.
And they're going to record it
Yes.
and provide me a copy.
Yes.
Yes.
All right, so we need to clarify this then. When there's one charge, perfectly normal to do an hour or two on one charge. I got 20 charges, so do I get 20 hours? No, that's silly. So
Yeah,
what
because
do
it's
I get?
all one event. I mean, you can only ask.
Not all
the-
one event, though. According to you, you
well,
denied a motion saying it
they're
wasn't all
couple
one
days.
event.
It's over a couple days. I don't know how long.
Couple days.
Your Honor, I think
This is
he's-
over 9 months.
Well,
Is he-
then
I'm sorry. Is he requesting that he be able to do pretrial interviews that are hours long, or is he asking for a trial? Or I don't.
I'm
know what
asking
he's
to do.
specifying.
I'm saying that when you, if there was just one charge, one charge, a pretrial interview that's an hour long is perfectly reasonable for one charge. Well, I got 20 charges, so I need an hour on each charge. That's 20 hours of
no,
pretrial interviews.
that's way too much.
Well, then I'm being prejudiced because
That's too much.
so then, but that's what I'm saying. We need to find a happy medium here because they're going to say one thing, but if I got, and you're saying now you're changing your thing because earlier in the other hearing you said it wasn't one event, so they could charge me with multiple charges for
It's
the
not
same
one
thing.
event. I'm wrong when I said it. It's over a course of time, but you don't need 20 hours.
I
to
didn't.
interview.
I'm not claiming I do. I'm saying I'm going from, what's normal is an hour for one charge to obviously that wouldn't be reasonable to have 20 hours, right?
Correct.
So where do we find something that is not prejudicial, that is fair for both sides? How do we come to that when we don't agree on anything? So is the judge going to have to decide that?
So, Mr. Myers, why don't you go through and just ask your questions, and if they become either repetitive or argumentative, then the state can say, hey, we're not going to allow this witness to be interviewed.
Whoa,
and then you
whoa,
can
whoa,
come
the
to
state
me.
doesn't-
Hold
this-
on. You can come to me, and we'll decide it.
The state doesn't get to say anything during the interview. The state isn't the witness's lawyer.
Mr. Myers, you have to behave yourself during the interview.
Oh, no, I'm not saying behave myself, but the state doesn't get to object to my questions.
Well,
No.
it's not a deposition. I've never had someone that had a problem interviewing witnesses.
Me neither.
So,
But my
we're-
point being
we're-
is you just made it seem like the state can object to my questions of the witness. No, the state can sit there and observe only. The law is clear on that. The state can sit there and observe. They're not representing the witness during the pretrial interview. They don't get to say we object to this question. No, they don't. That's clear.
Your Honor, I would just note that I can put a stop to the interview if he's becoming abusive in the process.
That's completely subjective, though.
well, but if you start yelling at somebody,
I'm not going to do that.
Okay, so I'm not going to get into.
I'm
putting
talking
a
about
time
like
limit.
they can say we object to that question.
Well,
it's
no,
not trial.
You can't object. You get to ask your question.
Right, that's what I'm saying. Right.
It's not a deposition. But if you're abusive or
That's
repetitive,
different. it.
then that's too much.
That's just being. That's just.
Mr. Myers, I'm
obligation to.
Correct.
I understand my professional obligation. I'm talking about the manipulation of the process where they try to object to a question or something.
Mr. Myers, I just said you can ask your questions
Thank
to your
you.
witness. You got to listen to what I'm
No,
saying.
I
okay?
heard what she said though. She said that if I object or whatever, and
No,
it's like
let's
she
we're
can't just.
gonna-
Your Honor, the plan would be that we will set up the interviews. If there is something that comes up during the interview process where we feel that the process should not continue forward, then we will stop the interview, and then we will file a motion with the court, and then the court can address it, and then we can
Yeah.
resume the interviews as
Mr. Myers, that's just how
necessary.
all discovery issues are happen.
This prejudicial language about you're already.
Okay.
Oh, Mr. Myers, if you're
Myers.
abusive, you're
No.
you're prejudicing me on the record.
No, I'm not.
No, she is. Oh, well, if
Listen,
he gets abusive,
no.
and then she said earlier,
Mr. Myers.
well, if he gets abusive, why don't I get a chance to uphold my professional obligations before we
Hold on.
come
You're
to these-
arguing about something that hasn't happened. I said you get to interview the witnesses. Just please
It's
listen to what I'm...
biasing me though.
No.
Not you,
no,
her.
No.
Saying,
no,
well, if he gets abusive,
no,
do
no.
they say that about every person? No,
Mr.
they
Myers.
don't. They don't say that when
Mr. Myers.
other people are going to do it.
You take the win. I said you could interview the witnesses.
Thank you.
They're not prejudiced. Nothing's happened yet. I'm not. I
This
don't.
constant reference on the record of me being a potentially being abusive and all this is just designed to prejudice
No,
me.
I don't work that way.
Well, then, do you allow other people? So when there's two defense attorneys sitting here, do they clarify and qualify every statement with, well, if he is if he's
Mr. Myers,
abusive or if
okay,
he's loud
Mr.
or
Myers,
if he yells?
Mr. Myers, I said you can interview the witnesses. That's the rule. That's all. That's all I've said. No more, no less. Okay, so we're going to come back in 2 weeks, and we're going to set a trial date unless the presiding judge
Different
grants
than
it.
the 21st?
No, remember we've only set it in one case. Remember,
But wouldn't they be on the same, now that it's consolidated, isn't it all one trial?
It should be, but you didn't want me to set that today.
Well,
Well, I can
because,
set it today if you want.
well, because, you know, like I said, and this isn't threatening, it's just the course of the proceedings.
Well, do you want
and
me to
the
set it or not, as to both cases?
Oh, I mean, I just wanted to make sure when you said that the one in the 21st didn't disappear.
No, it's still there,
Okay.
but I haven't set it to both cases.
That's
but
what I want to make sure
I intend to,
that
but
you
you didn't
didn't-
want me to do that today.
Right, I just wanted to make sure you didn't get rid of the 21st.
Nope.
That one's still there, the other one isn't, and I'm going to file my stuff. And now, as far as a disclosure request with them, how much, because, you know, this goes back to the original case at the beginning, the first case, right away in the case, I filed a request to basically a motion to compel. So, you know, you said, well, you got to have meet and confers and stuff. Well, how are we supposed to have meet and confers? And then when they're past their deadline, you know, I want to file, I believe at this point, they haven't disclosed things they should have. And you know, so how do we have this meet and confer if we don't have a chance to talk? Because I feel like I should be able to file a motion to compel already.
Well, if you think there are things that they haven't disclosed, you have to ask her for them first. And if she says, we're not going to disclose, then you can file a motion. I've not heard her say that they're withholding anything from disclosure.
Well, I already gave the motion, though. I mean, I already gave the request back at the beginning.
Well, follow up with her.
Okay.
Okay.
Because remember you
All right.
said I'm not going to rule on it yet?
I'm not going to rule because you have to meet and confer. That's a rule in the criminal.
And I want to
rules.
ask you a question about a settlement thing. Because they you know, they said they were going to report Parvin to the bar if he didn't force me to have a settlement conference. And
No.
so he came over there and tried to get me to sign this paper saying that he's not being unethical. So does that stop time?
So,
I'm not aware of that. I don't.
Your Honor, I have no idea what he's talking about. What I indicated with the settlement conference is if Mr. Myers is interested in a plea agreement, that we should go to a settlement conference so that we can have a discussion with the court and then work out the terms of that. And then my understanding from Mr. Parvin and Mr. Myers in court is that he is not interested in a settlement conference. I thought that would help facilitate a non-trial resolution if he is interested.
Mr. Myers,
in
I take
one.
it that you want to go to trial. If you want a settlement conference, she can try to request it before another judge, and you could both attend that if you'd like.
My question is does it stop time?
No.
No.
So you can still be on speedy trial and have one?
Yeah. Well, I'm going to set your trial within speed trial.
No, I know. And, you know,
The settlement conference doesn't.
somebody's lying because Parvin came to me 2 days ago and tried to get me to sign a form saying that he won't be held responsible for the Bar Association because Rachel was or Miss Stiles. Now, I'm not saying Miss Stiles said this. I'm saying what he told me. He came over there in a big panic. Oh, Miss Stiles is going to report me for ethical violations if we don't have a settlement conference. And I said, what? And she said, yes, she thinks that I'm stopping you from, remember now, this is third party, you know, secondhand, I'm just playing the telephone game here. It was presented to me that Miss Stiles is going at Parvin and saying that she thinks that he's being unethical by not convincing me to have a settlement conference. And then he came over there with this form he wanted me to sign saying, I told you about it and I can't be reported for ethics and I refused to sign it, right? So my thing is I've been in the jail for 35 days. I've talked to 65 people. I've read their plea bargains. Not one of them had a settlement conference and they got a plea bargain. So, and before the last hearing, Rachel was asking me about having a settlement conference. Well, why, you know, I get it, but why would you arrest somebody and indict them on all these charges and then not want to go to trial and convict me? So to me, that's a red flag. Okay.
So hold on, Mr. Myers. So the state can offer a plea if they want.
But why would they?
I'm not. They do oftentimes. They don't in every case.
Well, if they got all the evidence to convict me, why would they want to do a plea bargain?
Well, because trials are very time-consuming and expensive,
Yeah.
and people often will agree to a plea. But if you don't want a plea,
I sent them a plea bargain, and they have ignored me since at least 35 days. And why can't it be in front of the trial judge? Why does it need to be a different judge?
it's just the rule.
No, it isn't. It says if the parties agree, it can be the trial judge.
No, I'm not going to do that.
Okay.
Yeah.
So to me,
You can go to a settlement conference for a different judge if you.
is it confidential?
Yes.
Yes, it
And-
doesn't
and-
come back to me.
And to me, if they wanted to give me a plea, I would have got one in the mail already.
I don't
I
think
mailed her a plea.
Hold on, we're going down. If there's a plea in the case, I'll take your
Saying that
plea.
The settlement
don't get
conference thing is they keep asking for it. So is it something we
No,
need to do?
I think no. It has no effect on the trial. If you want to try to settle a case, and you're far apart, you can go to a settlement judge and try to negotiate a plea. But there's no obligation to do that. They don't have to give an offer, and you're not have to give an offer.
See, Parvin was in between us trying to block this settlement thing because he wanted to have his fancy little motions. You know what I mean? And so I told him to talk to her about a plea bargain, and he said no because I want to file these motions and challenge the statute. Okay. And so I said, well, if I at least want to hear what they got to say, but I'm not waiving time for that.
Yeah, no, the time is not waived. If you all want to talk about settlement, you can talk about it. Sometimes it facilitates it to have another judge conduct a settlement conference. Right. It's not required. That's all between you. I'm not going to continue the trial date for that stuff.
No, I don't want to. I'm saying because he was making it seem like it was either or. It was either we can file these motions and keep your speedy trial, but if we go to a settlement conference, you're waiving your speedy trial rights.
No, it doesn't waive speedy trial.
So is that something that we have to talk? Like, we can't set, the court has to set it. We don't have that without the court. It's a court officer's
So I can clarify. I will reach out to courts to find out who's available to do it. And
so there are judges who might be available, and typically one of the lawyers contacts the court, and Ms. Stiles can do that. And if you all want to attend one, you can attend it. That doesn't affect how the case proceeds.
How do we get to that point?
She'll make a request.
So if you're interested in doing it, I will just get it. I will contact the courts and get it set.
You need to talk to her about that.
Well, that's tough.
Well, you guys do that. That's not.
How do we even talk when I try to call there and the number's blocked? I know that's not. She didn't block me, but it's something with the jail not being able to call the prosecutor's office.
I will set up meetings. So I'm working on setting up so I can do a Teams visit with him at the jail. And then he can talk to me.
All right. We'll see you in 2 weeks. Okay. With that, we're adjourned to yours Tuesday.
Yeah.
Well, there you have it. The most recent Lane Myers hearing. I missed about 30 minutes of it at the beginning because I didn't realize that he had a hearing today until 30 minutes in. There's some other channels that are probably covering this, and I'll be trying to cover all the future hearings. Yeah, thanks for watching.